I'm Frances Robinson.
Hi, I'm Olivia Sanders.
I'm Abby Meek.
We have chosen to do question 2. You've been appointed by the prosecution in a case where a woman alleges that she is the victim of a rape. The alleged perpetrator was a colleague from work.
We hope you enjoy our video.
Let the court commence.
I call the trial of Alan Summers, who is on charge for the rape of Victoria Plummeridge. The burden of proof beyond reasonable doubt needs to be present. The trial is commencing on Thursday, the 28th of February at Buckinghamshire New University Court. I firstly call upon the defendant and the alleged victim to swear their oaths for the proceedings to take place.
I swear by the Bible that the evidence I give shall be the truth, the whole truth, and nothing but the truth.
I swear by the Bible that the evidence I give shall be the truth, the whole truth, and nothing but the truth.
Mr. Summers, do you know why you're here today?
Yes.
Do you know that you're being accused of the rape for Miss Plummeridge?
Yes.
And what do you plead?
Not guilty.
So, Miss Plummeridge, do you know why you're here today?
Yes,
So you're accusing the defendant, Alan Summers, for raping you, is that correct?
that is correct.
I now call upon the defence to open the case and outline the findings that will be brought before the jury. Defence, take the bench.
The case is involving Victoria Plummeridge, who alleges that she was raped by Alan Summers, who was a work colleague at Buckinghamshire New University offices. It is being argued that rape did not take place on the grounds that the victim did not report this to the police until 2 days after the alleged incident, that she did not have any wounds that suggest struggle, and that an ear witness, who will be called upon later, in the adjoining office, claims they did not hear any screaming at the time of the alleged offence. I would like to stress to the jury at this point that forensic evidence gathered from Victoria Plummeridge and her office, where the alleged rape took place, conclusively proves that sexual intercourse took place at Buckinghamshire New University at the said time and date between the defendant and the alleged victim. In dispute is whether this was rape. For the jury's benefit, the definition of rape, according to the Sexual Offences Act 2003, is when a person, A, commits an offence when he intentionally penetrates the vagina, anus or mouth of another person, B, with his penis, B, does not consent to the penetration, and A, does not reasonably believe that B consents. Now the jury understand the term rape. A major point of interest in this case is that the victim took 2 days to report the incident to the police. I put it to the courts that the said victim slept with the defendant, had second thoughts after having time to think, then for the sake of her career cried rape. Objection, Your Honour. If there is no evidentiary support, I suggest that statement is overlooked.
Objection granted.
Can I take this opportunity to call my first witness, an expert psychologist, to explain why this might be the case?
Permission granted. Take to the bench.
I call my first witness, the expert psychologist.
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth. I would like to start off by saying that as an expert witness in psychology who focuses on rape especially, that it does not at all mean that the victim was not raped purely because she took her time going to the police. In fact, if you were alleging you'd been raped, a general characteristic would be to delay when reporting to the police. An important thing to remember is that rape cases is a very personal and sensitive topic. Research in the area has highlighted many rape victims do not report to the police or there is a delay in reporting, as they can feel too embarrassed or ashamed of what has happened, they want to forget the event entirely, or they're afraid of the repercussions that may come from the assailant. And also they can be afraid of the legal proceedings, which can appear very daunting. The fact that the alleged perpetrator was a colleague can be a main factor to this, as the reporting of the rape could have made a huge impact on the said victim's life. Another point to make is that the relationship between the police and victims has not always been a positive one, with evidence showing lack of respect and neglect towards victims. It has been argued that the police only view victims as suppliers of evidence and will only show the victim's sympathy in order to ensure their cooperation.
Thank you, that is all for now. I would also like to state here that in the statement made by Miss Plummeridge, which the jury have a copy of, she had said that she had not come forward any earlier as she was so embarrassed and she was extremely worried what would happen at her job, which is her only form of a stable income, which is on line 43. Please carry on. In contrast, I would like to call my first witness, a doctor, to the stand.
Proceed. I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Is it true, Doctor, that the quicker the alleged rape victim comes forward, the more evidence you can gather?
Yes, this is true.
And that the longer it is left, it is harder to create a case?
Yes, this is also true.
And an explanation of this can be that if it is a false allegation and that there is in fact no evidence to support, this is why the victim chooses to delay in coming forward?
Yeah, that is one possible explanation.
That is all, thank you. Can I cross-examine the witness, Your Honour?
I have no objections. Carry on as you wish.
Would you say she was making it up, and do you think you can tell at all?
I feel after examining rape victims for over 15 years now, I can usually call a fake victim. And to me, Miss Plummeridge was genuine, as she was showing all indicators of a rape victim. She gave me no reason to doubt her. Also, reports of physical injury are less common than general health complaints following sexual assaults. Studies have found that sexual assault victims report more health symptoms. Examples of these can be rapid or pounding heartbeat, tension, headaches, nausea, etc. They report poorer perceptions of their health compared with non-victims. These were consistent with Miss Plummeridge, who suffered no injuries or wounds but had general health complaints that would coincide with a rape victim. Miss Plummeridge, when examined, had a racing heartbeat, menstrual symptoms, and had come out in rashes.
Do you think that because she left it 2 days before reporting it to the police, that this jeopardised the case in any way?
No, as after that time period we were still gathered the evidence to draw a conclusion that sexual intercourse had taken place and any wounds would have still been present, so no, the timing did not interfere. As this case, all the evidence needed was gathered after the 2-day period, which cannot always be done. It is not essential to have evidence and a prosecution can still go ahead without it. However, the sooner a rape is reported, the higher the chance of gaining forensic evidence to support the case. In this particular case, it was only 2 days, and you can report a rape case up to a year after the incident has occurred. Miss Plummeridge had to undergo a medical examination, which was intrusive and painful. The female anatomy rarely gets visible bruises or tears, and are noted even in confirmed sexual assault cases. Furthermore, what medical instruments were used during the examination can affect the likelihood of evidence being visible. In conventional rape examinations, without the use of coloscopes, only reported 19 to 28% of cases showed evidence of genital injuries. This is when compared with examiners who use the coloscopes find evidence of genital traumas in up to 87% of all cases. In my expert medical opinion, the lack of trauma is entirely consistent with the victim's version of events.
Thank you, that is all. Before the witness steps down, I would like to raise the second issue of the case towards the jury that the alleged victim did not have any wounds that suggested any struggle. This does imply that this was not a rape case, as there is no forensic evidence to suggest Miss Plummeridge objected to the sexual intercourse taking place.
Proceed.
I asked the doctor to explain this further for the benefit of the jury.
Yes, this is correct. The victim had no wounds or injuries that showed there was a fight or struggle. Whether or not the victim was received any bruising or injury should not be a reason to contest to the accusation, as research involving the comparison of physical injury on sexual assault survivors and consenting sexual contact found that 11% of the consenting women had genital trauma, thus suggesting that stating because the victim received no injuries does not mean she wasn't raped. Women can receive physical injuries during consensual and non-consensual sex.
Thank you, that is all. I wish to call upon the psychologist to shed some light on this matter.
Proceed.
Can I ask you to explain for the jury why this may be the case?
Thank you. Yes, it is true that the victim here sustained no physical injury, but that is not to say she was not raped. There is resounding evidence to suggest that using force is not necessary to show someone has been raped, as they may have been coerced by the defendant using threat of harm and other types of intimidation, such as threats to victim's child or family. The defendant can still be controlling the situation. It can still be seen as forcible rape, as it is sexual intercourse with the use of threat or force. However, this use of force does not always need to be physical. If the victim is afraid that harm will come to them, so instead of showing resistance, they choose to comply out of fear. This can also be seen with soft rape cases, where the perpetrator uses coercion to gain the victim's compliance. This can be in the form of psychological intimidation or threat of force. It is a misconception about rape that most victims will sustain physical injuries. This is simply not true. Research using lifetime cases from the National Women's Society showed that over 2/3 of victims reported no physical injury, only 4% received serious physical injuries, and 24% received minor physical injuries.
Thank you. I would just like to emphasise that the point the defence is making is simply untrue, taking into account evidence on rape cases, as you cannot discredit the victim by saying she was not raped purely because of lack of injury sustained, and they do not prove anything, as you cannot convict a man of rape over physical evidence, as every time someone had rough intercourse, they would be held on a rape charge. I'd like to raise a third point, that an ear witness who claims that they did not hear any screaming at the time of the alleged offence. I call upon this witness.
I do solemnly, sincerely and truthfully affirm that the evidence I give shall be the truth, the whole truth and nothing but the truth.
Miss Jones, can I ask you, did you hear anything at all strange on the afternoon of the alleged incident?
Not at all.
Do you think it sounded like someone was being raped in the adjoining office?
Definitely not.
Thank you, that is all. I would like to ask some questions, Your Honour.
Proceed.
Do you normally hear Miss Plumridge working in her office, carrying out daily activities, Miss Jones?
Most of the time, I can hear loud activities, phone calls, when she brings people into her office, that kind of thing.
Did you hear or think you heard Miss Plumridge having sexual intercourse with the defendant, Mrs. Jones?
No, as I said, I heard nothing.
Thank you, that is all. As you have heard, Miss Jones did not hear Miss Plumridge having sexual intercourse, which has been established happened, and she did not hear Miss Plumridge being raped, but it is clear to see that this is contradictory and cannot rule out that the defendant did not rape her. I would also like to call upon the psychologist again, who has some further information on this point.
Proceed.
Can you explain evidence that supports Miss Plumridge may have been raped, but as why we didn't hear any loud noises?
Yes, research has shown that fear of being physically injured is common, with National Women's Society, whose report showed that 49% of rape victims reported to be fearful of being seriously injured or killed during the attack. This fear can result in the victim becoming compliant, therefore being a possible reason for keeping quiet during an attack. Resisting and fighting a rape is not always possible. By not struggling, the victim will be able to minimise the harm that could possibly be done to them. It may be commonly assumed that during an assault, the first instinct would be the fight instinct. However, in rape cases, it is more common for victims to experience the freeze instinct, also known as tonic immobilisation, which can cause the victims to become still and silent. It has been found in studies that 88% of rape victims experience this type of instinct. Also, the assailant may have used restraints on the victim at the time of the rape, for example, gagging. This would also have prevented the victim from screaming out at the time of the attack.
After hearing all of the evidence from both the prosecution and the defence, the 3 points that have been argued upon are that Miss Plumridge did not report this alleged rape to the police until 2 days after the event. She did not have any physical wounds or abbreviations on her body, and finally, that the ear witness did not hear anything from the crime scene. To suggest a struggle or objection to sexual intercourse. As members of the jury, it is now your duty to consider all of these points raised in court to reach a verdict. They have reached their verdict and have found the defendant